Hello, my name is Anne McManus, and I'm your host today on Government Unlocked. We're very fortunate again to have our in-house expert on the Constitution, Dr. Jane Scarborough, and we're going to continue to talk about the Constitution, and particularly we're going to focus on the judiciary, which is really quite timely given all the decisions that are happening on a pretty much daily basis from our Supreme Court. So without any further ado, let's start. Jane, take us back to the beginning. What were the founders thinking when they put in a whole section on the judiciary? What role did they have for them?
Well, it's interesting, Anne, because Article 1 is the Congress, the legislature, and we said there was a reason for that because they were the closest to the people. They were the closest representatives to the people because every 2 years they turn over, they have to stand for election again. And so that was the first article, and there was a reason for that. And they were given what the founders thought was a really important power, and that is the power of the purse. Congress has the power, the only branch that has the power to initiate spending of money, federal money, and the final budget. The second article is the executive, and the third is the judiciary. So the first three articles set up the three branches. The judiciary gets kind of sparse treatment. The Article 3 is the briefest of the three articles. They start out simply saying that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time deem necessary and ordain and establish. So just the Supreme Court, and it gives Congress then the power to establish lower courts as time goes on. The rest of the article, there's a second section, and that deals with the jurisdiction of the courts, which we'll get into in a few minutes. That's the longest of the sections, but it isn't very long either. And then the final section gives the definition of treason, which under the Constitution is you have to have 2 eyewitnesses to the treasonous act or an in-court confession. So when you get to the judicial, they didn't think a whole lot about what the federal judiciary was going to be other than the Supreme Court. And when it came time for ratification, there was a lot of concern about this Supreme Court because they didn't have any courts under it. It sounded like...
And there was no real structure. The structure was going to be determined by Congress, correct?
Right. Now, the states had courts, and they had structure, but that was a concern then. What is this new federal court, Supreme Court, how is that going to interact with the state courts? And of course, that gets into the whole federalism. The underlying principles of the Constitution was federalism, this relationship between the states and the federal government, and the concept of separation of powers, which was to prevent any one branch from becoming too powerful. When they were debating in the Federalist Papers, which were really propaganda for
pro and con.
Well, it wasn't even pro and con. The Federalist Papers were all pro. They were all to increase the likelihood that this Constitution would be ratified. And so because there was concern about the Supreme Court that was set up in the Constitution, Alexander Hamilton wrote famously in one of the Federalist Papers that the court was going to be the weakest branch. The judiciary was going to be the weakest branch for 2 reasons. One, that it had a passive role. The court can't bring something to it and say, we want to make a decision about it. It has to wait till something comes to it legitimately under its jurisdiction. So because it's passive, that's one of the reasons he said it's the weakest. It doesn't give advisory opinions. The other reason is really because it has a limited jurisdiction. And we'll get into that in a minute.
Yeah.
That's the part that the founders were really counting on would help establish what the whole lower court system was going to be. One of the things in terms of how cases may be heard, which is what jurisdiction means, it means what's eligible, what cases are they empowered to hear. It's an issue that lawyers say the court has to, a case has to be justiciable. It's a fancy word.
I was going
that
to say,
means,
what does that mean?
Justiciable means eligible. It has to be eligible to be heard. So it's justiciable because it can go to the court. They can only hear certain kinds of cases and controversies. And cases and controversies are the words from the Constitution's third article about the judiciary. And that means that it has to be an adversarial situation. It can't be, again, just an advisory opinion. It has to be a case where there has to be a real adversarial position that involves a person or an organization that are bringing a case to the court. And that means that they have to be, they have to have standing. And standing means that if you bring a case to the court, you have to be able to show that there is some real perceived or imminent possibility of harm. Now that can be economic or personal or social, but you have to prove that you have standing to bring the case to the court.
But before it gets to that point, it's gone through a lot of other lower courts, correct?
It has.
And at that point, people are still unhappy with the decision of the lower courts, and that gives them the opportunity to apply to the Supreme Court.
Right.
But that doesn't mean the Supreme Court necessarily has to accept that.
Exactly. Actually, the Roberts Court has been very, I don't know if generous is the right word, but in finding that persons, one of the ways they have dismissed or not taken a lot of cases is they say that there isn't standing. So sometimes they will grant cert, which means if you want to come to the Supreme Court, the lawyers have to file a cert petition. Certiorari is the word, but people always shorten it to cert petitions. And certiorari just means, it's Latin, to be informed of. And the Supreme Court gets over 10,000 cert petitions asking them to review their cases.
And how many can they handle a year?
They hear about 60. And that's an important point, I think. We focus so much on the Supreme Court, but actually the federal system is huge. You have 94 federal district courts throughout the country. Now, the district court is the first level of federal courts, and that's the trial court, and that's where most cases are heard. The trial courts in any given year may hear 300,000 cases.
Wow. Yeah.
And when you think about the perspective of how much the Supreme Court hears, I mean, the Supreme Court hears less than 1% of the legal decisions that are made in any given year in our federal system. And yet there's so much focus on it because it has the power, the ability to really affect our lives, and does.
So if a case doesn't make it to the Supreme Court, the decision of the last court stands.
Right.
Yeah.
There are three levels. There's the district court, the trial court. Then there are the appellate courts. There are 9 of those. Well, there are now 13 of those, and those are circuit courts. And the circuit courts hear appeals from cases within their region. And there is one justice assigned to each of the circuit courts. Actually, obviously several of them have 2 circuits because there are 13 circuits at this point. And the circuit courts are where most of those cases stop. The circuit courts hear about 50,000 cases a year. So you go from 300,000 to 50 to then 60 or really less than 60 sometimes that are heard by the Supreme Court. Not only do you have to have standing to get your case possibly heard by the Supreme Court, to bring it, but you also have to, there has to again be a controversy. If the case is moot, if the things have been settled, they won't hear it. If it's been dismissed by a lower court, they won't hear it. They also have...
Is there any definition of what's a controversy, though?
Well, again, it has to be adversarial, and that's obviously a fact-determined issue. But that's where standing comes in, because sometimes they will say, for example, if the governors are challenging a federal policy, they may dismiss it because they don't feel the governors have standing to prove that that policy is really going to impact them. So that's what standing is about. And as I say, the Roberts Court uses standing a lot to dismiss cases they don't want to hear. But that is a legitimate issue in the courts.
And do the justices review, or they're probably
They're law clerks,
yeah,
right?
they review all these cases and then they make recommendations to the justices of what cases will be heard?
Yes, the law clerks presumably review all of the cert petitions, but obviously they're divvied up among the justices, law clerks. And the justices have 4 law clerks. The law clerks then do briefs for their justice about the cases and make recommendations of which ones to grant cert and hear. The justices meet every Friday during their terms in a conference that are just the justices. Nobody else is in there. The newest justice has to get the coffee and bring it in. At any rate.
Tradition.
Yes, tradition. So they decide in conference, they review, they take a quick kind of vote as to where things are with each of the justices, and then they discuss it, again, going from the most junior justice to the most senior in terms of each of them saying where they are and what they think about this. They often will carry over a case. We didn't decide it this week, so it'll be on next week's conference. And sometimes cases are carried over that they really can't. There's really strong feeling to take it on one side, but they don't really have the votes, they think. There's something called the rule of 4. It takes 4 justices to vote to hear a case, and that's it. Just if 4 justices say they want to hear it, then it's granted cert. So at these conferences, weekly conferences, they review what has been recommended, what their law clerks are passing on to them, and they make some decisions about not, dismissing a bunch of them from a hearing, and often the most controversial ones keep getting carried over until they can ultimately make a decision about whether to grant it or not. The rule of 4, with 4 justices, in today's court, there is clearly a block of conservative votes that makes it pretty easy to get the 4, Alito, Thomas, Gorsuch, and Kavanaugh usually. So it's not hard to guess which cases that are going there, which kinds of cases are probably going to get cert granted. And you can see that in the cases they're looking at. They have some political cases and some non-political cases. I mean, the non-political cases are usually, civil procedure, the civil code, business that isn't kind of influenced and which isn't by money. But the political cases.
So there's a real strategy to what gets certified. Right?
Well, or what
you'll push
yes.
it down the road until
Right.
you've got the votes,
Right.
and then
Right. And because lawyers know which ones are likely to vote to grant cert, the cases that are picked, I mean, this court, the Roberts Court, can almost always be relied on to take a case that involves church and state. They are chipping away at the religious church and state separation, and so those cases almost always get granted cert. Discrimination, civil rights gets granted.
How does that jive, though? Just to take a step back, the Constitution clearly delineates a separation of church and state. So how does that work, that a Supreme Court can be fuzzy on that?
Well,
I don't know if fuzzy's the right word.
no, that's a legal term, yes, along with squishy. Well, it's the facts and the law. And so here's the law, separation of church and state, First Amendment. So a case that was, I guess, last term, a state school district does not have provision to provide special needs within the district. So the district has responsibility for sending it somewhere else and paying for it. Can they use parochial schools for that? Well, yes. And so then taxpayer dollars are going to the parochial schools. So you have an issue whether or not, how are they going to, the state going to meet its requirement under the law, but what about the issue of taxpayer money going to a religious institution where they're not only going to get their independent educational plan met, but they're also going to get religious education along with it. So those are the kinds of cases, and it depends on the facts. But what this court has continued to do is to basically increase the likelihood of public funds going to religious schools because there's somewhat attack, maybe a little harsh, but there is a lot of pressure to give people choices of their schools, charter schools, public schools, parochial schools, and the courts have been very sympathetic to giving parents those choices and using those public funds to support those schools then when it's more than just their own religious training. I don't know if that helps or not.
Yeah,
but,
no, that helps.
But it's, you know, it's slicing the bologna thinner and
yeah, I was
thinner.
going to
Is
say,
the way we
it's
used
not,
to say it.
it's not a direct thing.
Right.
It's kind of
Right.
a slide towards.
Right. Well, in law school, as I say, we used to say slicing the bologna thinner and thinner to get a little bit, and then the next time around you get a little bit more. And so lawyers who are bringing cases know the kind of cases that this court is likely to take. And so they look for plaintiffs and they look for the arguments and the facts that they are likely to win on. And so, again, that's good lawyering in a way, but it's unfortunate when the court is so obviously slanted in certain ways and can be depended on to respond in certain ways, because you're looking at quite a competition with, 10,000 cert petitions, and you're going to maybe hear 60 of them. So if you look at what's on the court docket for each term as it comes up, you can see where the court keeps coming in: campaign finance, abortion, the places.
Big issues.
The big issues. Guns.
Yeah.
Guns are the biggest one. The closest tie between an issue and a political party is the issue of guns and laws to try to regulate guns.
So given that, we can expect to see more of those kind of cases coming to the Supreme Court.
Absolutely. In fact, this term that's going to start, it's going to start the first Tuesday in October, which is soon. This term has, I know, at least a case that, maybe two cases that they probably will put together about LGBT rights. It's kind of the wedding cake issue of.
Oh, yes.
It's back there again. It was sent back and it's back again. There is a gun regulation case. There is several civil rights issues of trying to decide at this point what constitutes discrimination, racial profiling, the kinds of things that are in the news and concerns. So you get a picture. These are
broad societal issues that
Right.
they're going to be addressing.
Right. But
Not just specific cases. They really have
Right.
large impacts.
Right. And that's where, as I say, the lawyers that practice before the court know what kinds of issues the court is wanting
Gravitating
to see.
to, yeah.
And in fact, you see that in justices' dissents. They will often give a clue of why, this would have been different if. So now the lawyers are looking for that set of facts and a good set of plaintiffs for that. So they give signals. I do want to talk about one piece of jurisdictional issues that limits the court's jurisdiction. The court itself has adopted a policy of what they call the political question doctrine. And that's where they say that if there is something that they see as basically a political question, they say the Constitution makes that more appropriate for the Congress, not us. And so they don't deal with it. And perhaps the most serious one of that, in my opinion, is that the court decided in 2019 that cases that involved partisan gerrymandering, where they are drawing up districts in their district to ensure that they go red or blue.
Which is a real issue right now.
Big issue.
Yeah.
The court decided in 2019 that that was a political issue and that they had it wasn't really in their jurisdiction to decide it. So that means there is no recourse now for the party who is not in power in the state and opposes what is being done with redistricting. They have no place to go. The courts aren't going to deal with it.
And that's why we see what's happening right now, that
Right.
governors are taking it into their own hands to
Right. I mean, that's exactly what's happening.
attempt to create some kind of balance.
Right. And what's strange about this, or really odd, is that they're doing it now. It's mid-decade. The redistricting was really tied to the census, which meant every 10 years the states would look at and what's changed in part is computers and AI, and they can now draw districts, within a street, to know exactly how many votes would be in that district likely for one party or the other. So they do things like what they call a majority-minority district, and they take maybe two districts that, let's say, have in the city and have gone Democratic. They combine those and make the representatives in those two run against each other. So now you just have one vote or one seat for that combined district, and it's a majority-minority district. They also do things like adding some minorities to a district, but they also add enough votes that they know will go their way. And so again, the redistricting is a serious problem. And the president recently called up, I guess it was Florida that he called up initially and said, I need you to get 5 more seats in the House out of your state. And so do redistricting. And so they did.
But the courts are staying out of this.
They're saying,
and so
there's no place for the minority group
so
to
it's
go.
going to play itself out.
It is.
The way it is playing itself out.
Right. The way it is playing itself out is those states, the Republican states, have started doing this, and again, middle of the decade. The Democratic states, particularly California, then said, well, we can play that game too, and are basically trying to neutralize this redistricting to try to at least keep the minimum margin that is now, if not increase it for the minority. So
if
yes,
things weren't so partisan in Congress, this is where that should be worked out.
Yes. And again, the polarization really started after Borg. When Borg, he was nominated for the Supreme Court, he was very conservative. He had a long record because he had been a judge, a circuit court judge, had lots of decisions and a lot of articles and speeches. And he basically was denied the appointment, the confirmation by the Senate. And ever since then, the confirmations have become basically theater.
Yeah.
They don't really get to anything.
Yeah.
And so again, the bipartisan is no bipartisan. It's just so polarized now. And again, go back to what the founders thought. The founders initially, remember, Washington was really opposed to political parties, and he kept saying he saw this as a problem for the Constitution. But by the time you get to the end of his administration, 2 terms, and he voluntarily steps down and sets that precedent, you already had the makings of the 2 parties. You had Alexander Hamilton, who had been his treasurer. You had Jefferson, who had been the state And he asked both of them to advise him on the various big issues. And they had such differing approaches that it was already clear that political parties were in the making. And certainly by John Adams comes along, they very much are in the making and they exist. So, but the political parties' compromise is something that summer in 1787, the founders, that hot summer, in their closed quarters, because everything that went on was confidential, nothing went outside, which was amazing. I'm trying to imagine that these days. They had to compromise on so many things, and that's where today the functioning of the federal government, certainly in Congress, does not seem to be working at all.
I think everyone can agree we need to get back to compromising.
Right, and that means talking to each other and recognizing nobody gets everything that they want.
We're going to talk more about that in the future, but one thing I really want you to talk about is, because it was a real eye-opener for me, was the whole issue of the emergency court or the shadow court, or the shadow docket.
Right.
I knew nothing about that, and I was like, it really was an eye-opener for me.
Right.
So could you talk a little bit about that?
Well, the shadow docket is something that name has been given to it recently, and I'd say in the last 20 years maybe. It wasn't always called the shadow docket. It was basically its emergency petitions to the Supreme Court to make a decision.
So we might hear it called that today, emergency decision, as
right.
opposed.
Or an order.
Okay.
They're procedural for the most part. They're not usually on the merits of something. It's procedural, so that you are looking for the court to step in and stay something that's going on, meaning to stop a decision from the lower court from going into effectiveness, and allowing that to go on through litigation, to take the normal courses, and the president who's asking for an emergency order is asking that the Supreme Court will stay that decision by the lower court. So if it's against his policies, if the Supreme Court stays the decision, it means the policies can continue to play out while the court issues with the merits of the case continue to go slowly through the system. So
and that could that take years?
It certainly could take more than a year, for sure. And depending on what it is, it can mean a lot more than a year. So the regular docket for the court are cases that come up in the usual way. We talked about the cert petitions, that if you want to get to the court, your lawyer has to file a petition, a petition of certiorari, or a cert petition, giving the court the facts, giving your briefs, and asking them to take your case. And so a docket is set up for the cases that they accept and as to when they will be heard. Those cases go through multiple briefs, go through oral argument, go through the court having the cases, the justices talking about them together, writing their opinions, passing those opinions around. The Chief Justice of the Supreme Court, Roberts, decides, when they finally take a rough count of where it stands, he decides who in the majority he's going to appoint to write the opinion. That person then writes the opinion and starts to circulate it. And in that process, it can change so that what was the majority is now not the majority, in which case it changes as to who's going to write it. That can actually and does happen in the process. The Chief Justice himself can choose and does choose often to write the major cases. And you can look at that from Shelby, which did away with the civil rights, the Voting Rights Act's, pre-clearance provision, which was the major provision of it. Roberts has written a number of the major decisions. So once that's circulated, and they work on the various drafts, then it actually can go up to when they actually have the print office print the final decision and the dissents, up to a day when it's supposed to be announced, and they can still change it. I mean, it's very interesting. The justices have
So they really work that.
they do.
But
And
once it's out,
but once it's announced and it's printed, all the dissents and the concurrences and the major opinion is out, then it's out and it goes into the big books that you see in the law
and basically
libraries.
that opinion is the rationale that they have come up with why they've made that determination.
Yes, and the court's major function is to clarify what the law is for all of those lower courts that we just talked about that are going to hear 300,000 at the trial court level and 50,000 at the appellate court level. They need to know, in the court, the Supreme Court's role is to make sure that there is uniformity in terms of what they have said is the law around a certain.
So that's the usual process.
Yes, that's the regular docket, and that gets sent out.
That's that what was it? How many cases were heard?
Oh, for the
I know 6,000 go up, but how many are heard?
about 60.
Okay, so that's one of those 60 cases.
Right.
Okay.
Goes
got it.
on to the docket, and the docket is put out at the beginning of the term. There are actually 3 terms for the court. I mean, you talk about the year session, but there's a term that begins in October, then there's a winter term, and then there's a spring term. And the court followers can figure out as they go along and as they announce some cases, and they do as they go along, not the biggies, they always save those for the very end and then they all flee town. When you see who has written, the Chief Justice tries to spread out the workload, and so you can start to begin to say, well, there hasn't been a decision by Kavanaugh yet, and this case coming up may be the one that he's going to give the opinion on. So there's that kind of watching by those of us who are that obsessed by this. So that's the normal way. But this emergency petition going from the government, and it's only the government that can ask for this. You and I couldn't.
It's only the federal government?
Yes.
Okay.
It's only the federal government. So that means the Department of Justice
Okay.
on the behalf of the president. Once they get one of these emergency petitions, they were intended initially for things like to stay an execution. That's a clear emergency for the person that's involved.
Absolutely.
So that's where they normally, in ordinary times, which means maybe back in the 40s and 50s, that's how it was primarily used. But increasingly, it's been used in a different way, in a way to kind of bypass, for the administration to bypass the implication of a lower court decision that goes against the policy they're trying to implement. And as it goes through the procedure, if the federal court, the trial court, has said that it's unconstitutional, they can't do it, the president may submit one of these emergency petitions asking the court to stay that decision, hold it, not implement it until it goes through the rest of the channels, the appellate, and then probably ultimately maybe up to the Supreme Court, till the litigation comes to the decision on the merits. This is a procedural request to stop it so I can continue to do my policy while you all in the court figure out whether I can do it ultimately or not.
Well, it's hard to kind of backtrack, though, once things are moving forward. So let's use the example of today. I think the person from the Federal Trade Commission.
Right.
I believe that was an emergency order to stop the president from executing his decision to terminate that person's employment.
Right.
Which I think, from what I gather, that's a big step, because usually the government has stayed out of that agency to
like
give
the
it some
Federal
independence.
Reserve. Same thing with the
Right.
Federal Reserve. So again, just to clarify, the shadow docket is in addition to the usual docket. And it's the court being asked to make a decision, not on the merits, meaning not on whether or not ultimately the decision goes one way or the other, but on a procedure to hold a lower court's decision in abeyance until it goes through the rest of the stages. So this order may come very early on in a lower court's decision. Maybe a federal court has decided it, it hasn't gone up to the appellate court yet. So in stopping it at that point, it allows the administration to continue to do what it's doing until there is an ultimate decision on the merits. That's the way the shadow docket is now being used, which is very different from in the past. It's a last-minute request, again, to stop some legal process until it all goes all the way through the courts. And that can be very slow, as we know.
And if you've terminated somebody's employment, it's
Right.
going to be difficult to fix that if
Right.
down the road the court does agree with you. That
Right. But used in this way, the emergency applications typically seek immediate intervention to allow administrative actions to continue that have been found unconstitutional in the lower courts to continue in effect until there's a final decision by whatever the final court, whether it's the circuit court or it's the Supreme Court itself. The president's current emergency petitions seem to center around policies involving immigration, federal funding decisions, executive authority over administrative agencies like the Federal Trade Commission, and social policy regulations.
Is this different than in the past? The use of this
It's
emergency
different, yes,
procedure?
it's different in scale. But all the presidents have used it in varying ways. But Trump has taken it to an art form. In his first administration, he issued 41 emergency petitions. In his second term, and we're only 8 months into it, he has already issued 22, 19 in the first 5 months. Now, Joe Biden, in his 4 years, issued 19 petitions in 4 years. That was a lot too, but nothing like what's going on now. And they were more, it was more diverse. They weren't all around certain issues. They didn't take the kind of predictability that we're seeing at these issues. Barack Obama and George W. Bush, both of them had 2 terms, so in 8 years, each of them only issued 8 emergency petitions. So it is building in scale. Yes, it's been used, but it is building in scale. The important part about these is that they come out as an order, often a paragraph.
So there's not a lot of explanation.
There's
as to
no
how the
explanation
determination-
other than the decision. Yeah. It's unsigned, typically, so you have no idea of which of the justices supported that decision. Sometimes the dissenters recently, Sotomayor has been writing a dissent to some of them, but you don't know how it was decided, why it was decided. You just know what was decided. So they may say, we're staying the Fifth Circuit's decision in this case until it's resolved.
Does this create a hardship for the lower courts?
Well, it kind of takes the legs out from under them, and there's been a lot written about how unusual and how seemingly contradictory it is for the Supreme Court Chief Justice to be kind of pulling the rug out from under his lower courts. There was a decision, I think a year or so ago, just last year actually, in which a lower court judge issued a nationwide injunction against, I think it was one of the immigration issues. And the Supreme Court, through an emergency petition, said, no, he can't do a nationwide injunction. He can only issue an injunction for his geographic jurisdiction. That was a huge slap on the lower courts because they have always been able to issue, in certain cases, a nationwide injunction. I mean, what would it make sense? So I issue an injunction in my state, but your state is still letting that policy go? It doesn't make any sense legally.
And it really runs in the face of federalism.
Absolutely.
Yeah.
And again, for the Chief Justice to be kind of doing that to his own courts is a little bizarre, actually, to say the truth. So these unsigned, unexplained orders, they undermine public confidence in the courts because it just underscores that.
Well, it's hard to understand them if there isn't a lot of explanation around them.
So it leads you to believe that this is strictly a personal decision, a political decision, because you have nothing to the contrary.
Context.
Right.
Yeah.
And that's not a good thing. And we already know that the court is at the lowest public opinion that it's ever had. Some of the scholars say when the court is doing this in the emergency petitions, that it's not operating as a court. He's not functioning as a court anymore because there are no briefs, no oral arguments, no detailed decisions telling you why. So it's not really functioning as a court should function. So there's a lot of criticism about this, and I think with good reason.
I think this is so much to digest. Obviously, we're seeing things happening in the court system that we all should be aware of.
Yes.
Because it has an impact nationally.
On all of us. I mean, the Supreme Court, even though we're saying it only looks at less than 1% of the cases that are in the jurisdiction, in the judicial system in a year, those decisions are important decisions and can impact all of our lives. And which is a reason that when the court issues decisions which are unsigned with no explanation, that is not helpful to people having some confidence of why the court is doing that.
Yes, it's important for us as people, we the people,
right,
to understand what our court system is doing
right,
and why they're doing it.
Right.
So I want to thank you because again, I think these are things I know for myself. These are things I am not aware of, and to learn about these things really heightens my awareness, and I hope folks out there will feel a greater sense of understanding of the challenges that we're facing and what we need to do.
The rule of law is the whole basis for our democracy. And so if we don't understand what's happening in the court systems, particularly when we see people's confidence falling away from believing they're doing really confidently, holding up the rule of law, then that's very problematic. And today, people really need to be aware of what's going on in the courts.
And we're going to leave it at that because that's the bottom line. I want to thank you for joining us today, and there'll be more to come on Government Unlocked. Thank you.